All right, good afternoon. I'm Erik Syverson with Steve Gebelin, bringing you the two-man Rains Feldman tag team cyber liability update. Normally we have Scott Lesowitz with us. Steve, I hear Scott Lesowitz is gambling and drinking in Las Vegas. That may or may not be true. Regardless, we'll go forward without him, and we are talking trade secrets litigation today. I am particularly interested in this because I am currently defending a bullshit trade secrets case. And today, Steve, we want to talk about what happens to plaintiffs that bring bullshit trade secrets cases in California. And this case is in the Central District, and we have an unreported opinion, but a very important opinion for any litigator defending a trade secrets case in California. And so in this case, we had the common scenario of a company. I don't know what kind of company this is. They're called RBC Bearings, as I read from this opinion. Some sort of industrial or aeronautical widget maker, and it sounds like they had an employee or a few employees leave and go to a competitor. And many times plaintiffs, in my experience, assume that when the employee goes to the new company that they have pilfered trade secrets. And they bring these trade secrets cases based on nothing but imagination and suspicion. And Steve, why don't you go into the case here and what happened to the plaintiff who apparently brought a trade secrets case and prosecuted it with no evidence and in bad faith.
So not only did they not have any evidence that there were trade secrets being stolen here, but throughout the litigation at multiple points the plaintiffs admitted they didn't have any evidence of trade secrets being stolen or being used by the competitor where these employees went to. Instead, they trucked on with this case for years, causing the defendants to rack up over $100,000 in attorney's fees that were paid to their attorneys.
And what were the trade secrets? What were the alleged trade secrets, I should say?
At the end of the day, the only ones that they held on to the end of the case was the client list. Just the names of the clients of the company. And the court found, and the plaintiffs even admitted, just those names alone aren't a trade secret. Just knowing who the clients aren't a trade secret unless there's some sort of extra special sauce to it. You know not only who you might sell to, but what their specific requirements are, and you've narrowed it out of a list of potentially thousands of people that you might sell your product to down to the 20 or 30 really good people to sell to. That might be a trade secret.
And is that California law or federal law?
It's under California law, but it's a standard that would probably be taken for persuasive effect elsewhere. This case was under the California Uniform Trade Secrets Act. So the decisional authority here applies in California.
And we also have some of these ancillary claims that we always see in trade secrets cases, right? We have the interference with business relations, we have the unfair business practices, we have all those sort of ancillary claims.
Conversion, all of those kind of extra tag-along claims.
And so let's cut to the chase of what happened in this case. We've established, I think, that it was a bullshit case. There were no trade secrets. And that certainly sounds familiar to me as someone who's, like I said, defending a BS trade secrets case. Now, what can happen to that plaintiff? They bring the case, it's garbage, they waste everyone's time, they waste everyone's money, the case goes away, and what happened here?
Well, what happened here is actually kind of interesting. So the summary judgment motion was filed by the defendants. Before the decision came down, the parties came to a settlement, agreed to dismiss the case, but subject to the defendants being able to seek costs from the court. Well, the defendants also sought attorney's fees, and they got them under the California Trade Secrets provision where defendants can get their attorney's fees back for specious claims by the plaintiffs.
Okay, so that's important. So it's not just you win or you lose, the trade secrets claims need to be specious.
Right. So it's something akin to the kind of standards we see in Rule 11 sanctions or other cases where, like you said, they're bullshit claims. There's no evidence here. There's no reason for them to continue prosecuting the case, but they still march on.
And in fact, that's interesting. So there's a couple of potential ways for defendants to right the ills of the plaintiffs. They could get their attorney's fees and costs back under this fee shifting provision of the Uniform Trade Secrets Act, right? And then also they could potentially get money back through Rule 11 sanctions. Although Rule 11 sanctions, sometimes the court orders the sanctions payable to the court, not a party. But it happens. And so did the court, in this opinion, touch upon Rule 11 sanctions at all?
The court actually did. It found the conduct by plaintiff's attorneys to be particularly egregious and mentioned that had the motion been brought as a request for Rule 11 sanctions or other sanctions, that that the defendants probably could have won there too.
All right. Well, I think that says it all. Trade secrets cases have, in my experience, a high percentage of being brought for wrongful purposes, fraudulent purposes, for purposes to punish ex-employees for leaving, for hurt feelings, for companies being overly defensive with regard to the marketplace. And that's not to say that they're always frivolous. There's certainly plenty of times when trade secrets cases are meritorious. But you've got to actually have a trade secret to bring them. That's really step one, isn't it, Steve? So here we had a case where the plaintiff should have known they didn't even have a trade secret. So there are some weapons out there for those companies and individuals and employees who have been sued wrongfully for trade secrets. So I think this case is a good lesson to plaintiffs, and I think it's instructive to defendants because you can get your fees back, and you may also get Rule 11 sanctions. And there's a third option. You may, after prevailing, bring a malicious prosecution action. I would think that's also in the cards. So 3 ways to strike back against plaintiffs in these cases. That's all the time we have for now. That was the Raines-Feldman Cyber Liability Update, and we'll see you next time.